Question 1. The monitoring system demonstrates that a new open-end management investment company's Form N-1A registration statement has been submitted for principal review in California. Which of the following approaches best ensures compliance with federal securities laws and the protection of potential investors? Option A. Conduct a detailed review of the Form N-1A, paying particular attention to the sections on investment objectives, strategies, risk factors, and fees to ensure accuracy and completeness of disclosure. Option B. Rely on the fund manager's assurances that all information presented in the Form N-1A is accurate and complete, as they are most familiar with the fund's operations. Option C. Prioritize the review of the Form N-1A's formatting and visual appeal to ensure it is presented in a professional and easily readable manner for investors. Option D. Approve the Form N-1A based on the initial review conducted by the fund's legal counsel, assuming their expertise covers all necessary disclosures. Correct answer is A. Conduct a detailed review of the Form N-1A, paying particular attention to the sections on investment objectives, strategies, risk factors, and fees to ensure accuracy and completeness of disclosure. Explanation. This scenario is professionally challenging because it requires a principal to balance the efficient processing of regulatory filings with the absolute necessity of accurate and complete disclosure to potential investors. Misrepresenting or omitting material information in a Form N-1A can lead to significant regulatory penalties, investor harm, and reputational damage for the firm. The principal's judgment is critical in ensuring that the registration statement meets all legal and ethical obligations. The best approach involves a thorough review of the Form N-1A, specifically focusing on the sections detailing the investment objectives, strategies, risks, and fees. This approach is correct because it directly addresses the core purpose of the registration statement: to provide investors with all material information necessary to make an informed investment decision. Under the Securities Act of 1933 and the Investment Company Act of 1940, registrants have a strict liability for material misstatements or omissions in registration statements. Principal's duty includes ensuring compliance with these acts, which mandates full and fair disclosure. This proactive and detailed review ensures that the fund's prospectus accurately reflects its operations and potential risks, thereby protecting investors and the firm from regulatory scrutiny. An approach that prioritizes speed by relying solely on the legal department's initial review is incorrect. While legal review is crucial, it may not always encompass the operational nuances or the practical implications of the disclosed strategies and risks from a sales and marketing perspective. The principal has a supervisory responsibility to ensure the accuracy of information disseminated to the public, which extends beyond a purely legal interpretation. This approach risks overlooking disclosures that, while legally sound, might be misleading in practice or fail to adequately warn investors of specific risks associated with the fund's intended operations. Another incorrect approach is to approve the Form N-1A based on the assumption that the fund manager's representations are inherently accurate and complete. This abdicates the principal's supervisory responsibility. The principal must exercise independent judgment and due diligence, verifying information where necessary and ensuring that the disclosures align with the firm's understanding of the fund's operations and the market. Relying solely on the fund manager's word without independent verification can lead to the dissemination of inaccurate or incomplete information, violating the principal's duty of supervision and the regulatory requirement for accurate disclosure. Finally, an approach that focuses primarily on the aesthetic presentation and formatting of the Form N-1A rather than its substantive content, is fundamentally flawed. While clear and organized presentation is important for readability, it does not substitute for the accuracy and completeness of the information itself. Regulatory compliance hinges on the substance of the disclosures, not merely their appearance. This approach prioritizes superficial aspects over the critical legal and ethical obligations of full and fair disclosure, exposing the firm to significant risk. Professionals should adopt a decision-making framework that emphasizes a comprehensive understanding of the regulatory requirements, a diligent review of all material information, and a commitment to investor protection. This involves cross-referencing disclosures with operational realities, seeking clarification on ambiguous points, and ensuring that the final registration statement provides a clear, accurate, and complete picture of the investment opportunity. Question 2. Operational review demonstrates that a registered representative in Ontario, Canada, is experiencing significant personal financial distress, including substantial debt and potential bankruptcy. As their sales supervisor, what is the most appropriate immediate course of action to ensure compliance with Ontario Securities Commission (OSC) regulations and Investment Industry Regulatory Organization of Canada (IIROC) rules? Option A. Immediately escalate the situation to the firm's compliance department and senior management for review and guidance. Option B. Advise the representative to continue their sales activities as normal, assuring them that personal issues should not impact professional performance. Option C. Suggest the representative discreetly transfer their client accounts to another registered representative within the firm to reduce their immediate workload. Option D. Offer the representative a personal loan from your own funds to help alleviate their immediate financial pressure. The correct answer is A. Immediately escalate the situation to the firm's compliance department and senior management for review and guidance. Explanation. Scenario analysis. This scenario presents a common challenge for sales supervisors in Ontario, Canada, where a registered representative is experiencing significant personal financial difficulties. The challenge lies in balancing the firm's obligation to supervise its employees and ensure compliance with regulatory requirements, particularly those related to suitability and preventing undue influence, with the need for empathy and support for the representative. The supervisor must act decisively to protect clients and the firm without unfairly penalizing the representative, all while adhering to the Ontario Securities Commission (OSC) regulations and the Investment Industry Regulatory Organization of Canada (IIROC) rules. Correct approach analysis. The best professional approach involves immediately escalating the situation to the firm's compliance department and senior management. This is correct because it triggers the firm's established internal procedures for handling such sensitive situations. The compliance department is equipped to assess the potential impact on clients, review the representative's current book of business for any signs of compromised judgment or unsuitable recommendations, and determine the appropriate course of action, which may include temporary reassignment or enhanced supervision. This approach ensures that the firm fulfills its supervisory responsibilities under OSC Rule 31-505, registration requirements, registration exemptions, and other Ontarian registration matters, and IIROC Dealer Member Rule 1300, supervision. It prioritizes client protection and regulatory adherence by involving the appropriate expertise within the firm. Incorrect approaches analysis. One incorrect approach is to offer the representative a personal loan or financial assistance. This is professionally unacceptable because it creates a direct conflict of interest. The supervisor's role is to supervise, not to provide personal financial support, which could compromise their objectivity and create an appearance of impropriety. It also bypasses the firm's compliance framework and could violate IIROC rules regarding conflicts of interest and ethical conduct. Another incorrect approach is to advise the representative to simply tough it out and continue their sales activities as usual, assuming their personal issues will not affect their professional conduct. This is a serious regulatory failure. It demonstrates a lack of due diligence and supervisory oversight, potentially exposing clients to unsuitable recommendations driven by the representative's financial distress. This directly contravenes the spirit and letter of OSC and IIROC rules that mandate active supervision to ensure client interests are paramount. A further incorrect approach is to encourage the representative to transfer their client accounts to another registered representative without proper disclosure or assessment. While seemingly helpful, this action, if not handled through the firm's established procedures and compliance oversight, can lead to regulatory breaches. It risks inadequate client communication, potential suitability issues with the new representative, and a failure to properly document and supervise the transition, all of which are contrary to IIROC client-centric rules and OSC registration requirements. Professional reasoning. Professionals facing such a situation should utilize a framework that prioritizes regulatory compliance and client protection. This involves 1. Recognizing the potential conflict and risk. 2. Immediately consulting internal compliance and legal departments. 3. Documenting all communications and actions. 4. Ensuring all decisions align with applicable securities laws and industry regulations. 5. Avoiding personal involvement in financial matters of supervised individuals. that could create conflicts of interest. Question 3. Process analysis reveals that a registered principal in a New York-based broker-dealer firm has noticed several individuals in the sales department have recently been assigned new responsibilities that involve client interaction and the recommendation of securities, but their registration status has not been formally reviewed since their initial hiring. What is the most appropriate course of action for the principal to ensure compliance with Section 15 of the Securities Exchange Act of 1934 and relevant FINRA rules regarding broker-dealer registration in New York? Option A. Focus on the firm's overall sales performance and address individual registration issues only if they directly impede the firm's ability to generate revenue. Option B. Delegate the responsibility of verifying all sales personnel's registrations to the Human Resources Department, trusting their administrative processes to manage compliance. Option C. Conduct a comprehensive review of all sales personnel's current job duties and verify that each individual possesses the appropriate and current FINRA registration, initiating new filings or amendments as necessary. Option D. Assume that individuals hired into sales roles are adequately registered and address any registration discrepancies only if they are identified by FINRA or during an internal audit. The correct answer is C. Conduct a comprehensive review of all sales personnel's current job duties and verify that each individual possesses the appropriate and current FINRA registration, initiating new filings or amendments as necessary. Explanation. Scenario analysis. This scenario is professionally challenging because it requires a registered principal to balance the firm's operational needs with strict regulatory compliance regarding the registration of its personnel. The principal must proactively identify potential registration gaps and address them without compromising the firm's ability to conduct business or exposing it to regulatory sanctions. Failure to do so can result in significant penalties, including fines and disciplinary actions against both the firm and the individuals involved. Correct approach analysis. The best approach involves a proactive and systematic review of all individuals performing functions that require registration as a representative or principal. This includes cross-referencing job duties with FINRA definitions of covered activities and verifying that each individual has a current and appropriate registration filed with FINRA via Form U-4. This approach directly addresses the regulatory requirement under Section 15 of the Securities Exchange Act of 1934 and relevant FINRA rules, ensuring that all personnel engaged in security sales or supervision are properly registered before undertaking such activities. It prioritizes compliance and risk mitigation by identifying and rectifying potential issues before they lead to violations. Incorrect approaches analysis. One incorrect approach is to rely solely on the assumption that individuals hired into sales-related roles are automatically registered. This overlooks the critical responsibility of the firm and its principals to verify and maintain accurate registration records. It creates a significant compliance risk, as individuals may be performing unregistered activities, leading to violations of Section 15 and applicable FINRA rules. Another incorrect approach is to only address registration issues when they are flagged by regulators or during an audit. This reactive stance is insufficient and exposes the firm to potential penalties for past unregistered activity. Regulatory frameworks mandate ongoing compliance and proactive measures to ensure registration requirements are met at all times. A further incorrect approach is to delegate the entire responsibility for verifying registrations to the Human Resources Department, without direct oversight from a registered principal. While HR can assist with administrative tasks, the ultimate responsibility for ensuring that individuals performing regulated functions are properly registered rests with the firm's principals. This delegation can lead to oversight and gaps in compliance, as HR may not possess the specific regulatory knowledge required to identify all registration obligations. Professional reasoning. Professionals should adopt a risk-based approach to compliance. This involves regularly assessing potential areas of regulatory exposure, such as personnel registration. A robust internal control system should be in place that includes periodic reviews of job functions and corresponding registrations. When a potential gap is identified, the principal should immediately initiate the process to rectify the situation, which may involve filing a Form U-4, ensuring appropriate training, or reassigning duties if registration is not feasible. This proactive and diligent approach minimizes regulatory risk and upholds ethical standards. Question 4. The evaluation methodology shows that a principal at a FINRA member broker-dealer located in California must ensure the firm's compliance with registration requirements. If the firm has recently ceased all business operations at a previously registered branch office in Nevada, what is the most appropriate course of action for the principal to take regarding the firm's registration for that location? Option A. Assume that the cessation of business activity at the physical location will be automatically reflected in the firm's registration status by regulatory authorities. Option B. Immediately initiate the necessary filings with FINRA and the Nevada Secretary of State to terminate the registration of the physical office location where business operations have ceased. Option C. Inform the registered representatives who were previously assigned to that office that they should no longer conduct business from that location, without formally updating the firm's registration. Option D. Wait for the next scheduled annual renewal of registrations to update the information, assuming the cessation of business at the office is a temporary measure. The correct answer is B. Immediately initiate the necessary filings with FINRA and the Nevada Secretary of State to terminate the registration of the physical office location where business operations have ceased. Explanation. The evaluation methodology shows that a registered principal's responsibility extends to ensuring the firm's compliance with all regulatory requirements, including the proper initiation and termination of broker-dealer and physical office registrations. This scenario presents a professional challenge because the principal must balance the firm's operational needs with strict adherence to FINRA and state regulations, particularly when dealing with potential regulatory oversights or changes in business operations. A failure to act promptly and correctly can lead to significant regulatory penalties and operational disruptions. The best approach involves proactively identifying the need to update the firm's registration information with FINRA and the relevant state securities regulators. This entails a thorough review of the firm's current operational footprint, including all physical office locations, and comparing it against the registered information. Upon identifying discrepancies or changes, the principal must initiate the necessary filings through the appropriate channels, such as the FINRA CRD system, to amend or terminate registrations as required. This proactive and meticulous process ensures the firm remains in good standing with regulators, avoids potential fines for noncompliance, and maintains the integrity of its operational structure. This aligns with the core duty of a principal to supervise and ensure compliance with all applicable rules and regulations governing broker-dealers. An incorrect approach would be to delay initiating the termination of a physical office registration after the business activity has ceased. This failure to promptly update regulatory filings can result in the firm being cited for operating an unregistered branch office or for maintaining inaccurate registration information, leading to fines and disciplinary actions. Another incorrect approach is to assume that a change in business activity at a physical location automatically updates the firm's registration without formal notification. Regulatory bodies require explicit filings to reflect such changes, and relying on implicit understanding is a significant compliance failure. Finally, an approach that prioritizes the convenience of not filing amendments over regulatory accuracy, such as continuing to list an office as active when it is not, demonstrates a disregard for compliance obligations and exposes the firm to regulatory scrutiny. Professionals should employ a systematic risk assessment framework when managing registration requirements. This involves establishing clear internal procedures for tracking office locations and business activities, conducting regular audits of registration data against actual operations, and fostering a culture of compliance where timely reporting of changes is paramount. When faced with a potential change in office status, the decision-making process should prioritize regulatory accuracy and prompt notification over expediency. Question 5. System analysis indicates that a registered representative in your New York branch office has been arrested for a misdemeanor offense. While you have heard rumors about this through office gossip, the representative has not yet informed you or filed any amendments to their Form U-4. As a Series 23 General Securities principal, what is the most appropriate immediate course of action to ensure compliance with FINRA regulations? Option A. Assume the misdemeanor offense is personal and not a reportable event under FINRA rules, and therefore take no action. Option B. Wait for the representative to voluntarily report the arrest and file the necessary amendments to their Form U-4. Option C. Directly and professionally inquire with the registered representative about the arrest and their understanding of their reporting obligations. Option D. Immediately report the arrest to FINRA based on the office gossip, without confirming the details with the representative. The correct answer is C. Directly and professionally inquire with the registered representative about the arrest and their understanding of their reporting obligations. Explanation. Scenario analysis. This scenario is professionally challenging because it involves a registered individual's personal life impacting their professional obligations. A supervisor must balance the firm's regulatory compliance requirements with an employee's privacy and potential personal distress. The core challenge lies in ensuring accurate and timely updates to the CRD system, which is a fundamental regulatory mandate, without overstepping professional boundaries or creating an environment of distrust. The supervisor's judgment is critical in determining the appropriate level of inquiry and intervention. Correct approach analysis. The best professional practice involves directly and professionally inquiring with the registered representative about the status of their legal proceedings and the necessity of updating their CRD. This approach acknowledges the representative's responsibility to report such events while offering support and guidance within professional limits. It aligns with FINRA Rule 1122, which mandates that all information filed with FINRA must be accurate and complete, and requires registered persons to amend their Form U-4 promptly upon the occurrence of certain events, including arrests or legal actions. By initiating a direct conversation, the supervisor facilitates compliance and demonstrates a commitment to supporting the representative in meeting their regulatory obligations. Incorrect approaches analysis. Failing to inquire directly and instead relying on rumor or indirect information is a significant regulatory failure. This passive approach risks noncompliance with FINRA Rule 1122, as it delays or prevents the necessary amendment to the Form U-4. It also demonstrates a lack of proactive supervision, which is a key responsibility of a principal. Assuming the legal matter is personal and therefore not reportable without confirmation is also a critical error. Many legal proceedings, including arrests and indictments, are reportable events under FINRA rules, regardless of the outcome. This assumption can lead to a material omission on the CRD, violating the accuracy and completeness requirements. Immediately reporting the situation to FINRA without first speaking to the registered representative is an overreaction and potentially breaches professional conduct. While prompt reporting is crucial, a direct conversation allows for clarification and ensures that the information provided to FINRA is accurate and complete, and that the representative has been given an opportunity to fulfill their reporting obligations. It also fosters a more supportive supervisory relationship. Professional reasoning. Professionals should adopt a proactive and communicative approach to regulatory compliance. When faced with potential reportable events concerning a registered representative, the decision-making process should involve 1. Identifying the potential regulatory requirement, e.g., FINRA Rule 1122 regarding Form U-4 amendments. 2. Directly and professionally engaging with the individual to gather facts and understand their reporting obligations. 3. Providing guidance and support to ensure compliance. 4. Escalating or reporting as necessary based on confirmed information and regulatory requirements. This structured approach ensures accuracy, fairness, and adherence to regulatory standards. Question 6. Quality control measures reveal that a registered representative in your New York branch office has resigned shortly after allegations of unauthorized trading and misrepresentation of investment products were raised internally. As the sales supervisor, what is the most appropriate immediate course of action regarding the firm's regulatory obligations in New York? Option A. Advise the representative that their resignation will be processed without further inquiry and delay the Form U-5 filing until any informal inquiries are resolved. Option B. Encourage the representative to withdraw their resignation to allow for a more thorough internal review before any reporting is made to FINRA. Option C. Initiate an immediate internal investigation into the allegations and prepare to file the Form U-5 reflecting the resignation and any substantiated findings within the regulatory timeframe. Option D. File the Form U-5 immediately, stating only that the representative resigned, and address the allegations only if a formal regulatory inquiry is initiated. Correct answer is C. Initiate an immediate internal investigation into the allegations and prepare to file the Form U-5 reflecting the resignation and any substantiated findings within the regulatory timeframe. Explanation: this scenario is professionally challenging because it involves a critical juncture in a registered representative's career and necessitates strict adherence to FINRA rules regarding resignations, particularly when potential misconduct is involved. The supervisor's actions must balance the firm's obligations to FINRA and the departing representative's rights, while also safeguarding the integrity of the securities markets. The supervisor must exercise careful judgment to ensure all reporting requirements are met accurately and promptly, without prejudicing the representative unnecessarily or failing to disclose material information. The best approach involves immediately initiating the firm's internal review process to investigate the allegations thoroughly, and, concurrently, preparing the necessary Form U-5 filing. This approach is correct because FINRA Rule 1120 and the associated guidance on Form U-5 require firms to report certain events, including terminations or resignations, and to disclose any disciplinary actions or allegations of misconduct. Promptly investigating the allegations allows the firm to gather facts to accurately complete the Form U-5. Filing the Form U-5 within the mandated timeframe, typically 30 days of the termination or resignation, is a strict regulatory requirement. Furthermore, if the investigation substantiates the allegations, the Form U-5 must reflect this accurately, potentially including details about the nature of the misconduct. This proactive and compliant approach ensures transparency with regulators and the public, fulfilling the firm's duty of oversight and reporting. An incorrect approach would be to delay the Form U-5 filing until the internal investigation is fully concluded, especially if that conclusion extends beyond the regulatory deadline. This failure to file within the prescribed 30-day window violates FINRA Rule 1120 and demonstrates a lack of diligence in fulfilling reporting obligations. Another incorrect approach is to file the Form U-5 without mentioning the pending investigation or the specific allegations, especially if those allegations are material and could impact the representative's ability to engage in securities activities. Omitting such information, even if the investigation is ongoing, can be misleading to regulators and future employers. Finally, attempting to influence the representative to withdraw their resignation before the Form U-5 is filed to avoid reporting obligations is a serious ethical and regulatory breach. This circumvents the reporting requirements and undermines the integrity of the regulatory system. Professionals should approach such situations by first understanding the specific FINRA rules governing resignations and terminations, particularly those related to Form U-5. Should then activate internal compliance procedures for investigating allegations of misconduct. Documentation is paramount. All steps taken, findings and communications should be meticulously recorded. If a resignation occurs concurrently with allegations, the firm must assess whether the resignation is voluntary or if it is effectively a termination in disguise due to the alleged misconduct. This assessment dictates the appropriate disclosures on the Form U-5. Consulting with the firm's compliance department and legal counsel is crucial to ensure accurate and timely reporting and to navigate any complexities. Question 7. Stakeholder feedback indicates that the firm's current practices for retaining customer account records in California are inconsistent. As a Series 23 General Securities principal, you are tasked with evaluating the firm's approach to ensure compliance with FINRA Rule 4511. Which of the following represents the most effective and compliant approach to record retention? Option A. Assign the primary responsibility for record retention to a newly hired administrative assistant with minimal prior experience in regulatory compliance, without providing specific training or oversight. Option B. Rely on the informal knowledge and established routines of long-serving administrative staff to manage the retention and disposal of customer records. Option C. Develop and implement a comprehensive, written record retention policy that clearly outlines retention periods, record types, and storage methods, supported by regular staff training and periodic internal audits. Option D. Adopt a policy of discarding older records that are no longer actively referenced to minimize storage costs and physical clutter. Correct answer is C. Develop and implement a comprehensive written record retention policy that clearly outlines retention periods, record types, and storage methods, supported by regular staff training and periodic internal audits. Explanation. This scenario presents a professional challenge because it requires a principal to balance the firm's operational needs with the regulatory imperative to maintain accurate and complete records for a specified period. The principal must exercise careful judgment to ensure compliance without unnecessarily burdening the firm or compromising data integrity. The best professional practice involves proactively establishing a clear, documented policy for record retention that aligns with FINRA Rule 4511 and other applicable regulations in California. This policy should define the types of records to be retained, the retention periods, and the methods of storage, e.g., electronic, physical. Regular training for staff on this policy and periodic audits to ensure adherence are crucial components. This approach is correct because it demonstrates a commitment to regulatory compliance, minimizes the risk of inadvertent violations, and provides a consistent framework for managing records, thereby fulfilling the principal's supervisory responsibility. An incorrect approach involves relying solely on the memory or informal practices of long-term employees. This is professionally unacceptable because it creates significant risk of inconsistent application, potential loss of critical records due to employee turnover or oversight, and a lack of demonstrable compliance if audited. It fails to meet the supervisory obligations mandated by FINRA Rule 4511, which requires firms to establish and maintain procedures for record retention. Another incorrect approach is to adopt a when in doubt, throw it out mentality for older records. This is professionally unacceptable as it directly contravenes the minimum retention periods stipulated by FINRA Rule 4511. Destroying records prematurely, even with good intentions to reduce storage costs or clutter, can lead to severe regulatory sanctions and reputational damage. It demonstrates a failure to understand and implement the firm's record retention obligations. Finally, an incorrect approach is to delegate record retention responsibilities entirely to a junior administrative assistant without providing adequate training, resources, or oversight. While delegation is necessary, abdication of supervisory responsibility is not. This approach is professionally unacceptable because it places an undue burden on an unqualified individual and increases the likelihood of errors and noncompliance, ultimately failing the principal's duty to supervise the firm's operations and ensure adherence to regulatory requirements. Professionals should approach record retention by first understanding the specific regulatory requirements, e.g., FINRA Rule 4511 for broker-dealers in California. They should then develop a comprehensive written policy that addresses all aspects of record retention. This policy should be communicated to all relevant personnel, and regular training and audits should be conducted to ensure its effectiveness. Proactive policy development and ongoing oversight are key to fulfilling supervisory duties and maintaining regulatory compliance. Question 8. The evaluation methodology shows that a registered representative in California has been consistently recommending complex option strategies to a broad range of retail clients, generating substantial commissions. As a sales supervisor, what is the most appropriate immediate course of action to ensure compliance with the Securities Exchange Act of 1934 and protect investors? Option A. Wait for client complaints to arise before initiating a review of the representative's sales practices related to complex option strategies. Option B. Focus primarily on the representative's commission revenue as a measure of success, assuming that high earnings indicate appropriate client engagement. Option C. Immediately suspend the representative's authority to sell complex option strategies pending a comprehensive review of their client base and the suitability of all recommendations made. Option D. Allow the representative to continue selling these strategies while requesting them to voluntarily report any instances where they believe a recommendation may have been unsuitable. Correct answer is C. Immediately suspend the representative's authority to sell complex option strategies pending a comprehensive review of their client base and the suitability of all recommendations made. Explanation. The evaluation methodology shows that a registered representative in California has engaged in a pattern of recommending complex option strategies to retail clients without adequate due diligence. This scenario is professionally challenging because it pits the firm's obligation to supervise against the representative's potential for generating commissions, and it requires a supervisor to navigate the fine line between legitimate sales practices and potentially fraudulent or unsuitable recommendations under the Securities Exchange Act of 1934 and FINRA rules, which are applicable in California. The best approach involves immediately halting the representative's sales of these complex option strategies pending a thorough review of their client base and the suitability of the recommendations made. This proactive measure demonstrates a commitment to client protection and regulatory compliance. Specifically, Rule 10b-5 of the Securities Exchange Act of 1934 prohibits manipulative and deceptive devices in connection with the purchase or sale of securities. Recommending complex strategies without proper due diligence can be construed as deceptive. Furthermore, FINRA Rule 2111, Suitability, mandates that firms and their associated persons have a reasonable basis to believe a recommended transaction or strategy is suitable for a particular customer based on the customer's investment profile. Halting the activity allows for an objective assessment of whether this standard has been met, thereby mitigating further potential harm to clients and the firm. An incorrect approach involves continuing to allow the representative to sell these strategies while simultaneously requesting the representative to self-report any instances of unsuitability. This approach fails to adequately protect investors. It places the burden of identifying and reporting potential violations on the individual who may have a conflict of interest, commission generation, and delays necessary intervention. This passive stance could be seen as a failure of supervisory responsibility under the Securities Exchange Act of 1934, which imposes a duty on firms to supervise their registered representatives. Another incorrect approach is to only review the representative's recommendations after a client complaint has been filed. This reactive strategy is insufficient. The Securities Exchange Act of 1934 and associated regulations emphasize proactive supervision and prevention of harm. Waiting for a complaint means that harm may have already occurred, and the firm may have failed in its duty to supervise, potentially leading to significant regulatory sanctions and reputational damage. Finally, an incorrect approach would be to focus solely on the representative's commission earnings as an indicator of performance, without scrutinizing the underlying sales practices. While profitability is a business consideration, it cannot supersede the regulatory and ethical obligations to ensure that recommendations are suitable and that no manipulative or deceptive practices are occurring. As prohibited by the Securities Exchange Act of 1934, professionals should adopt a proactive and risk-based approach to supervision. This involves establishing clear policies and procedures, conducting regular training, monitoring sales activities for red flags, such as a pattern of recommending complex products to unsophisticated investors, and taking immediate corrective action when potential issues are identified, rather than waiting for complaints or relying solely on self-reporting. Question 9. Compliance review shows that a candidate for a sales supervisor position in California has a past regulatory action from FINRA related to an oversight failure that was resolved 5 years ago. What is the most appropriate next step for the hiring firm? Option A. Approve the candidate's hiring without further investigation, assuming that the past action is too old to be relevant. Option B. Immediately disqualify the candidate from consideration due to the existence of any past regulatory action, regardless of its nature or resolution. Option C. Approve the candidate's hiring but implement a standard, non-specific enhanced supervision plan for all new supervisors. Option D. Conduct a thorough review of the specific nature of the FINRA regulatory action, its resolution, and the candidate's subsequent professional conduct to assess their suitability for the supervisory role. Correct answer is D. Conduct a thorough review of the specific nature of the FINRA regulatory action, its resolution, and the candidate's subsequent professional conduct to assess their suitability for the supervisory role. Explanation. Scenario analysis. This scenario presents a professional challenge because it requires a supervisor to balance the firm's obligation to hire qualified individuals with the need to conduct thorough due diligence on potential candidates. The presence of a past regulatory action, even if resolved, necessitates careful consideration to ensure compliance with FINRA rules and protect the firm and its clients. A superficial review could lead to regulatory violations and reputational damage. Correct approach analysis. The best professional practice involves a comprehensive review of the candidate's background, specifically focusing on the nature and resolution of the prior regulatory action. This approach aligns with FINRA Rule 3110, Supervision, and the general principles of responsible hiring. A thorough investigation would include understanding the specifics of the disciplinary action, the reasons for its imposition, and the steps taken by the candidate to rectify the situation. This allows for an informed decision about the candidate's suitability for a supervisory role, considering whether the past issues pose a current risk. Incorrect approach is analysis. One incorrect approach is to immediately disqualify the candidate solely based on the existence of a past regulatory action without further investigation. This fails to acknowledge that FINRA rules often allow for individuals with past disciplinary history to be employed, provided appropriate supervisory measures are in place. It also overlooks the possibility that the candidate has demonstrated rehabilitation and learned from past mistakes. Another incorrect approach is to approve the candidate's hiring without any specific inquiry into the nature or resolution of the regulatory action. This demonstrates a lack of due diligence and a failure to adequately assess the risks associated with employing an individual with a disciplinary record. It could be seen as a violation of the firm's supervisory responsibilities under FINRA rules, as it bypasses a critical step in evaluating a candidate's fitness for a role that demands a high degree of trust and compliance. A further incorrect approach is to approve the candidate's hiring, but impose a generic, one-size-fits-all supervisory plan that does not specifically address the issues raised by the past regulatory action. While some level of supervision is necessary, a plan that is not tailored to the candidate's specific history may be insufficient to mitigate potential risks and could still fall short of FINRA supervisory requirements. Professional reasoning. Professionals should approach pre-hire background checks with a commitment to thoroughness and a nuanced understanding of regulatory requirements. The decision-making process should involve 1. Identifying any red flags in the background check, such as regulatory actions. 2. Conducting a detailed investigation into the nature, severity, and resolution of any identified issues. 3. Assessing the candidate's current fitness for the role, considering any mitigating factors or evidence of rehabilitation. 4. Developing a specific and effective supervisory plan if the candidate is hired, tailored to address any residual concerns. This systematic approach ensures compliance, protects the firm, and upholds ethical standards. Question 10. Analysis of a situation in New York where a registered representative, Mr. Smith, has been operating an undisclosed outside business activity, UBA, involving the sale of artisanal cheeses. As a principal, you become aware of this UBA on March 1st. You estimate that Mr. Smith has generated approximately $5,000 in gross revenue from this UBA in the past year, with an estimated net profit of $1,500. The UBA was initiated on January 15th of the previous year. What is the latest date by which the firm must ensure an amendment to Mr. Smith's Form U4 is filed reflecting this UBA? Option A, April 14th of the current year. Option B, January 15th of the current year. Option C, immediately upon confirmation of the UBA regardless of profit. Option D, March 31st of the current year. Correct answer is A, April 14th of the current year. Explanation. Scenario analysis. This scenario presents a common challenge for principals overseeing registered representatives. The principal must balance the firm's obligation to maintain accurate and timely filings with the representative's responsibility to disclose material changes. Failure to properly amend Form U4 can lead to regulatory sanctions, reputational damage, and potential liability for both the representative and the firm. The mathematical element introduces a layer of complexity, requiring precise calculation and adherence to specific timeframes. Correct approach analysis. The best professional practice involves immediately initiating the amendment process for Form U4 once the principal becomes aware of the undisclosed outside business activity. This proactive approach ensures compliance with FINRA Rule 3270 and NAST Rule 3010, as incorporated by FINRA rules, which mandate prompt disclosure of such activities. The calculation of the potential financial benefit, while not directly part of the amendment filing itself, is crucial for assessing the materiality and potential conflicts of interest, which informs the firm's supervisory procedures. The firm must ensure the amendment is filed within the required timeframe, typically within 30 days of the principal's knowledge of the activity. Incorrect approach is analysis, failing to initiate the amendment process until the representative explicitly confirms the activity is a significant regulatory failure. This delays compliance and exposes the firm to risk. The principal has a supervisory duty to investigate and act upon information that suggests a potential violation, not wait for a confession. Waiting for the representative to file the amendment themselves without firm oversight is also unacceptable. The principal's role is to supervise, which includes ensuring that required filings are made accurately and on time. Relying solely on the representative abdicates this responsibility. Calculating only the direct income from the activity and ignoring potential future earnings or the value of the business itself is an incomplete assessment. While the amendment requires disclosure of the activity, the firm's internal risk assessment should consider the broader financial implications to ensure adequate supervision. The regulatory requirement is to disclose the activity, and the firm's internal policies should guide the depth of financial analysis for supervisory purposes. Professional reasoning. Professionals should adopt a principle-based approach to compliance. When faced with information suggesting a potential disclosure violation, the immediate priority is to verify the information and initiate the necessary corrective actions, which in this case includes amending Form U4. This involves understanding the firm's supervisory responsibilities and the specific disclosure requirements under FINRA rules. A proactive and thorough approach to information gathering and regulatory filing is paramount. Question 11. The review process indicates that a registered representative in a New York-based brokerage firm has consistently failed to update customer account records with accurate transaction dates, leading to a discrepancy between the system's recorded dates and the actual settlement dates for a significant number of trades executed over the past quarter. As the sales supervisor, what is the most appropriate course of action to address this situation? Option A. Immediately initiate a detailed review of all affected customer accounts, cross-reference the system's recorded dates with original trade confirmations and settlement statements, and meticulously document all discrepancies and corrective actions taken to ensure the firm's records are accurate and compliant with SEC Rule 17a3 and FINRA Rule 4511. Option B. File a report with FINRA detailing the discrepancies and await further instructions before taking any corrective action on the firm's internal records. Option C. Instruct the registered representative to provide a written explanation for the discrepancies, and then proceed with correcting the records based on their explanation without independent verification. Option D. Advise the registered representative to correct the discrepancies in the system at their earliest convenience and monitor the situation informally to ensure the issue is resolved. Correct answer is A. Immediately initiate a detailed review of all affected customer accounts, cross-reference the system's recorded dates with original trade confirmations and settlement statements, and meticulously document all discrepancies and corrective action taken to ensure the firm's records are accurate and compliant with SEC Rule 17a3 and FINRA Rule 4511. Explanation. The review process indicates a potential breakdown in a firm's supervisory responsibilities concerning the maintenance of accurate and accessible customer account records. A critical component of the Series 23 exams focus on Section 17 accounts and records, reports, examinations of exchanges, members, and others. This scenario is professionally challenging because it requires a principal to not only identify a deficiency, but also to implement corrective actions that uphold regulatory compliance and protect customer interests. The principal must balance the need for efficient operations with the stringent requirements for record keeping and supervision. The best professional practice involves a proactive and thorough approach to identifying and rectifying record-keeping discrepancies. This includes immediately initiating a comprehensive review of the affected accounts, cross-referencing the problematic entries with original source documents and transaction confirmations, and documenting all findings and corrective actions taken. This approach ensures that the firm's records are not only accurate but also readily available for regulatory examination, thereby fulfilling the firm's obligations under FINRA Rule 4511 and other relevant regulations. It demonstrates a commitment to regulatory compliance and a robust internal control environment. An incorrect approach would be to dismiss the initial finding as a minor clerical error without further investigation. This fails to acknowledge the potential for systemic issues or more significant compliance breaches. It neglects the principal's duty to supervise and ensure the integrity of the firm's records, which could lead to regulatory sanctions if discovered during an examination. Another incorrect approach is to rely solely on the registered representative to correct the records without direct oversight or verification by the principal. While registered representatives are responsible for the accuracy of their work, the principal bears ultimate supervisory responsibility. This abdication of oversight can result in uncorrected errors or the masking of more serious compliance violations. A further incorrect approach is to delay the review and correction process until a formal request is received from a regulatory body. This reactive stance is contrary to best practices and regulatory expectations, which emphasize prompt identification and remediation of compliance issues. Such a delay can exacerbate the problem and lead to more severe consequences during an examination. Professionals should approach such situations by prioritizing a culture of compliance and accountability. This involves establishing clear procedures for record keeping and supervision, conducting regular internal audits, and empowering principals to take decisive action when deficiencies are identified. A commitment to continuous improvement and a thorough understanding of regulatory requirements are essential for effective supervision. Question 12. Performance analysis shows that a registered broker-dealer in Ontario, Canada, is experiencing significant financial difficulties, leading to concerns among its clients about the safety of their investments. A principal is reviewing client inquiries regarding potential compensation for losses. Which of the following approaches best addresses the principal's responsibility in this situation under the Securities Investor Protection Act of 1970, SEPA? Option A. Determine if the firm's financial distress has resulted in its inability to meet its obligations to customers, specifically concerning the delivery of securities or the return of cash held for their accounts, as this is the primary condition for SEPA protection. Option B. Focus on the client's individual financial needs and advise them to seek personal financial counseling, as SEPA is a complex regulation and the firm's general financial health is the only relevant factor. Option C. Advise all clients experiencing investment losses that SEPA will cover their losses, as the firm is clearly in financial trouble and this is a standard protection. Option D. Immediately initiate a claim with the Securities Investor Protection Corporation, SIPC, for all clients who have incurred any investment losses, regardless of the cause, to ensure prompt compensation. The correct answer is A. Determine if the firm's financial distress has resulted in its inability to meet its obligations to customers, specifically concerning the delivery of securities or the return of cash held for their accounts, as this is the primary condition for SEPA protection. Explanation. Scenario analysis. This scenario is professionally challenging because it requires a principal to distinguish between the protective scope of the Securities Investor Protection Act of 1970, SEPA, and situations that fall outside its purview. Misinterpreting SEPA applicability can lead to significant client dissatisfaction, regulatory scrutiny, and potential firm liability. A principal must exercise careful judgment to ensure clients receive appropriate guidance and that firm resources are allocated effectively. Correct approach analysis. The best professional practice involves accurately assessing whether the firm's financial difficulties are the direct cause of customer losses due to the firm's insolvency or failure to meet obligations, which is the core trigger for SEPA protection. This approach correctly identifies that SEPA is designed to protect customers from losses arising from the failure of a broker-dealer, not from market-driven investment losses. By focusing on the firm's financial condition and its ability to meet its obligations to customers, the principal is adhering to the fundamental purpose of SEPA. This aligns with the regulatory framework established by SEPA and the Securities Investor Protection Corporation, SIPC, which aims to restore customers to the position they would have been in had the firm not failed, up to certain limits, for cash and securities held by the firm for their accounts. Incorrect approaches analysis. One incorrect approach involves assuming SEPA automatically covers all client losses experienced during a period of firm financial distress. This fails to recognize that SEPA protection is contingent on the firm's insolvency and its inability to meet its obligations to customers. Market depreciation of securities, even if significant, is not a covered event under SEPA. This approach risks mismanaging client expectations and potentially initiating unnecessary SIP claims. Another incorrect approach is to dismiss SEPA entirely based on the firm's general financial health without a specific assessment of its ability to meet customer obligations. While the firm may have other assets, if it cannot deliver customer securities or cash, SEPA may still be applicable. This approach overlooks the specific trigger for SEPA protection, the firm's failure to meet its obligations to customers. A further incorrect approach is to focus solely on the client's perceived financial hardship without investigating the underlying cause of the potential loss in relation to the firm's operational status. SEPA is not a general financial assistance program. It is a specific protection mechanism tied to broker-dealer failure. This approach deviates from the regulatory intent of SEPA by conflating client need with the specific conditions for SIP coverage. Professional reasoning. Professionals should adopt a systematic approach when faced with potential SEPA claims. This involves 1. Understanding the specific circumstances of the client's potential loss, particularly whether it stems from the firm's financial condition or market fluctuations. 2. Reviewing the firm's financial statements and operational status to determine if it is insolvent or unable to meet its obligations to customers. 3. Consulting SIP guidelines and legal counsel if there is any ambiguity regarding SEPA applicability. 4. Communicating clearly and accurately with clients about the protections available and the limitations of SEPA. Question 13. The performance metrics show a significant upward trend in a particular municipal bond fund managed by your firm. A registered representative, eager to capitalize on this, begins discussing the fund with potential clients, highlighting its recent strong performance and suggesting it is a sure bet for future gains. In the state of New York, which of the following actions by the registered representative best adheres to the principles of Rule 15C1-3 of the Securities Exchange Act of 1934 regarding misrepresentation? Option A. The representative downplays or omits any discussion of the risks associated with municipal bonds, focusing solely on the positive performance metrics. Option B. The representative emphasizes only the recent positive performance without any cautionary statements about future expectations or risks. Option C. The representative accurately presents the fund's historical performance, clearly states that past performance is not indicative of future results, and provides all relevant disclosures, including the risks associated with municipal bond investments. Option D. The representative guarantees a specific rate of return based on the recent performance trend. The correct answer is C. The representative accurately presents the fund's historical performance, clearly states that past performance is not indicative of future results, and provides all relevant disclosures, including the risks associated with municipal bond investments. Explanation. The performance metrics show a significant upward trend in a particular municipal bond fund managed by your firm. A registered representative, eager to capitalize on this, begins discussing the fund with potential clients, highlighting its recent strong performance and suggesting it is a sure bet for future gains. This scenario is professionally challenging because it pits the representative's desire for sales success against the firm's obligation to provide accurate and non-misleading information to investors, particularly concerning municipal securities where disclosure requirements are stringent. The representative's statements risk violating Rule 15C1-3 of the Securities Exchange Act of 1934, which prohibits brokers, dealers, and municipal securities dealers from misrepresenting material facts about securities. The best professional approach involves the registered representative accurately presenting the fund's historical performance, clearly stating that past performance is not indicative of future results, and providing all relevant disclosures, including the risks associated with municipal bond investments. This approach aligns with the spirit and letter of Rule 15C1-3 by avoiding any implication of guaranteed future returns or misrepresentation of the security's nature. It prioritizes investor protection by ensuring they receive a balanced and truthful picture of the investment opportunity, allowing them to make informed decisions based on facts rather than speculative pronouncements. An incorrect approach involves the representative emphasizing only the recent positive performance without any cautionary statements about future expectations or risks. This misrepresents the investment by creating an overly optimistic impression and failing to disclose material information about the inherent uncertainties of market performance, thereby violating Rule 15C1-3, prohibition against misrepresentation. Another incorrect approach is for the representative to guarantee a specific rate of return based on the recent performance trend. This is a direct misrepresentation and a violation of Rule 15C1-3, as no investment can be guaranteed, and such a statement is inherently misleading. A further incorrect approach would be for the representative to downplay or omit any discussion of the risks associated with municipal bonds, focusing solely on the positive performance metrics. This selective disclosure constitutes a misrepresentation of the overall investment profile and fails to provide clients with the complete information necessary for a sound investment decision, contravening Rule 15C1-3. Professionals should adopt a decision-making framework that prioritizes regulatory compliance and ethical conduct. This involves a thorough understanding of applicable rules, such as Rule 15C1-3, and a commitment to transparent communication. When discussing investments, representatives must always qualify performance data with appropriate disclaimers regarding future results and risks, ensuring that all material information is disclosed. If unsure about the appropriateness of a statement, seeking guidance from a supervisor or compliance department is a critical step in preventing regulatory violations and protecting client interests. Question 14. Investigation of a registered representative's assistant in California reveals that the assistant has been independently contacting prospective clients to schedule meetings for the registered representative to discuss investment opportunities. The registered representative has not yet submitted a Form U-4 for the assistant, although they intend to do so. What is the most appropriate immediate action for the firm's principal? Option A. Immediately cease all client-facing activities by the assistant and ensure the Form U-4 is filed promptly for the assistant's registration. Option B. Inform the assistant that their current activities are acceptable, but they must refrain from discussing any specific investment products. Option C. Allow the assistant to continue scheduling meetings while the Form U-4 is being processed, as the activity is preparatory and not directly selling securities. Option D. Advise the registered representative to handle all client communications directly until the assistant's registration is approved. Correct answer is A. Immediately cease all client-facing activities by the assistant and ensure the Form U-4 is filed promptly for the assistant's registration. Explanation. This scenario presents a professional challenge because it requires a principal to balance the firm's operational needs with strict adherence to FINRA registration requirements, specifically concerning the supervision of unregistered individuals. The principal must make a judgment call that upholds regulatory integrity while also addressing a potential business disruption. The core tension lies in ensuring that all individuals engaged in activities requiring registration are properly registered before undertaking such activities, even if it means temporarily halting certain business functions. The best approach involves immediately ceasing any activities that require registration by the unregistered individual and formally initiating the registration process. This aligns directly with FINRA Rule 1120, which mandates that all persons associated with a member firm must be registered in the appropriate capacity before engaging in the securities business. By taking this action, the principal ensures compliance with regulatory obligations, prevents potential violations, and safeguards the firm from regulatory sanctions and reputational damage. This proactive stance demonstrates a commitment to ethical conduct and regulatory adherence. An incorrect approach would be to allow the unregistered individual to continue performing their duties while the registration process is underway, perhaps with the justification that the work is administrative or preparatory. This is a direct violation of FINRA Rule 1120. The rule does not permit a grace period for unregistered individual to perform activities that necessitate registration. Such an action exposes the firm to significant regulatory scrutiny, fines, and potential disciplinary actions, and it undermines the integrity of the registration system designed to protect investors. Another incorrect approach would be to dismiss the concern by assuming the individual's activities are not covered by registration rules. This demonstrates a lack of understanding or willful disregard for the scope of FINRA registration requirements. The definition of securities business is broad, and many activities, even if seemingly administrative, can be construed as requiring registration if they involve interaction with customers or the facilitation of securities transactions. Relying on assumptions rather than seeking clarification or adhering to the rule is a critical ethical and regulatory failure. Finally, an incorrect approach would be to prioritize the firm's immediate business needs over regulatory compliance by seeking a temporary waiver or exception from FINRA. FINRA does not typically grant waivers for fundamental registration requirements. The regulatory framework is designed to be absolute in its application, to prevent unregistered individuals from engaging in regulated activities. Attempting to circumvent established rules, even with good intentions, is a serious breach of professional conduct and regulatory obligation. Professionals should employ a decision-making framework that begins with a thorough understanding of applicable regulations, such as FINRA Rule 1120. When faced with a situation involving potential registration gaps, the first step should be to verify the individual's registration status and the nature of their activities. If there is any doubt or a clear indication of noncompliance, the immediate priority must be to halt the noncompliant activity and initiate the correct registration process. Escalating the issue to compliance or legal departments for guidance is also a crucial step in ensuring proper handling. The overarching principle should always be to err on the side of caution and prioritize regulatory adherence to protect both the firm and investors. Question 15. Comparative studies suggest that broker-dealers expanding their operations into new states often face challenges in navigating the intricacies of registration. For a broker-dealer currently registered with the SEC under the Securities Exchange Act of 1934, what is the most prudent and compliant course of action when intending to conduct business in California for the first time? Option A. Register the firm at the federal level and rely on the existing state registrations of individual registered representatives to cover California operations. Option B. File an updated Form BD with the SEC reflecting the intention to do business in California and simultaneously file the necessary registration forms and pay applicable fees with the California Department of Financial Protection and Innovation. Option C. Wait for a specific inquiry from California regulators before initiating any state-specific registration processes. Option D. Assume that SEC registration under Rule 15b 1-1 is sufficient for all states, including California, and proceed with business operations. The correct answer is B. File an updated Form BD with the SEC reflecting the intention to do business in California and simultaneously file the necessary registration forms and pay applicable fees with the California Department of Financial Protection and Innovation. Explanation: this scenario presents a professional challenge because a registered broker-dealer is seeking to expand its operations into a new state without fully understanding the specific registration requirements. Misinterpreting or overlooking these requirements can lead to significant regulatory violations, fines, and reputational damage. Careful judgment is required to ensure compliance with the Securities Exchange Act of 1934 and the rules promulgated thereunder, specifically Rule 15b 1-1, which governs the application for registration. The best professional approach involves proactively identifying and fulfilling all necessary registration obligations in the new jurisdiction. This means thoroughly researching the specific state's securities laws and regulations, which often mirror federal requirements but may have unique nuances or additional filing mandates. For a broker-dealer registered with the SEC, this typically includes filing a Form BD with the Securities and Exchange Commission, SEC, and also ensuring that the firm and its associated persons are appropriately registered with the relevant state securities regulator in each state where they conduct business. This proactive and comprehensive approach ensures that the firm operates legally and ethically from the outset in the new market. An incorrect approach would be to assume that SEC registration automatically covers all state-level requirements. This overlooks the dual regulatory system in the United States, where both federal and state authorities oversee the securities industry. Failing to file the necessary state registration forms or pay state-specific fees constitutes a violation of state securities laws and the Securities Exchange Act of 1934, which mandates registration in each jurisdiction where a broker-dealer effects transactions. Another incorrect approach is to delay state registration until a specific inquiry or issue arises. This demonstrates a lack of due diligence and a disregard for regulatory obligations. Operating in a state without proper registration is a serious violation and can result in enforcement actions, including fines and prohibitions from conducting business. Finally, an incorrect approach is to only register the firm at the federal level and assume that individual associated persons will be covered by their existing registrations in other states. While associated persons must be registered in the states where they operate, the firm itself must also be registered in each state where it conducts business. This failure to register the entity in the new state is a direct violation of registration requirements. Professionals should adopt a systematic decision-making framework that prioritizes thorough research and proactive compliance. Before expanding into any new jurisdiction, a comprehensive review of all applicable federal and state securities laws and regulations is essential. This includes understanding registration requirements for both the firm and its personnel, as well as any ongoing reporting or compliance obligations. Consulting with legal counsel specializing in securities law can also be invaluable in navigating complex jurisdictional requirements. Question 16. The investigation demonstrates that a prospective registered representative applicant for a securities firm in California has disclosed a prior disciplinary action from a state securities regulator that occurred 10 years ago. The applicant states the action was minor and did not involve fraud or misrepresentation. What is the most appropriate course of action for the firm's principal to ensure compliance with federal securities laws and FINRA rules regarding the ineligibility of certain persons for membership or association? Option A. Immediately notify FINRA of the prior disciplinary action and request a determination regarding the applicant's eligibility for association. Option B. Conduct an internal investigation to assess the severity of the past disciplinary action before notifying FINRA. Option C. Proceed with the applicant's registration, assuming the disciplinary action is too old to be a disqualifying factor. Option D. Advise the applicant that the firm cannot proceed with their registration due to the past disciplinary action without further review. Correct answer is A. Immediately notify FINRA of the prior disciplinary action and request a determination regarding the applicant's eligibility for association. Explanation. This scenario is professionally challenging because it requires a principal to balance the firm's regulatory obligations with the potential impact on an individual's livelihood. The principal must navigate the complexities of FINRA Rule 3110 and the Securities Exchange Act of 1934, specifically concerning the ineligibility of certain persons for association with a member firm. A thorough understanding of the rules governing registration, background checks, and the disclosure of disciplinary history is paramount. The principal's judgment is critical in determining whether the disclosed information warrants immediate action or further investigation, ensuring compliance while acting ethically. The best approach involves a direct and proactive engagement with the applicant and FINRA. This entails immediately notifying FINRA of the applicant's prior disciplinary action and requesting a determination regarding their eligibility for association. This approach is correct because it adheres strictly to the regulatory framework. FINRA Rule 3110 mandates that member firms supervise their registered representatives and ensure that all persons associated with them are registered and eligible. By proactively engaging FINRA, the firm fulfills its supervisory duty and seeks official guidance on a potentially disqualifying event. This demonstrates a commitment to compliance and prevents the firm from inadvertently associating with an ineligible person, thereby avoiding potential sanctions. An incorrect approach would be to proceed with the applicant's registration without seeking FINRA explicit approval after discovering a prior disciplinary action that could impact eligibility. This fails to meet the firm's supervisory responsibilities under FINRA Rule 3110, which requires firms to have procedures in place to prevent the association of ineligible persons. Furthermore, it bypasses the regulatory process designed to vet individuals with potentially disqualifying backgrounds, creating a significant compliance risk for the firm and potentially exposing investors to harm. Another incorrect approach is to assume the applicant is eligible simply because the prior disciplinary action occurred several years ago and the applicant claims it was minor. Eligibility is a matter of regulatory determination, not personal assessment. The firm cannot unilaterally decide that a past disciplinary event is no longer relevant to an individual's current eligibility for association without FINRA review. This approach ignores the explicit requirements for disclosure and FINRA authority to make such determinations. Finally, an incorrect approach would be to delay the notification to FINRA while conducting an internal investigation to assess the severity of the past disciplinary action. While internal due diligence is important, the regulatory obligation to notify FINRA of potentially disqualifying events is immediate. Delaying notification can be interpreted as an attempt to circumvent regulatory oversight and could lead to penalties for the firm. The firm's primary responsibility is to comply with the reporting requirements and then to cooperate with FINRA's subsequent review. Professionals should adopt a decision-making process that prioritizes regulatory compliance and transparency. When faced with information that could impact an individual's eligibility for association, the first step should always be to consult the relevant regulatory rules. In this case, FINRA rules and the Securities Exchange Act of 1934. If the information suggests a potential ineligibility, the firm must proactively engage the regulatory body FINRA for guidance and a formal determination. This ensures that the firm acts in accordance with the law and ethical standards, protecting both the firm and the investing public. Question 17. In the state of New York, a securities firm is registered with the SEC as a broker-dealer. The firm's business model involves exclusively introducing customer accounts to a clearing firm, and it does not directly hold customer cash or securities. The firm's management believes that because they do not directly solicit business from retail investors and do not hold customer assets, they are not required to be members of the Securities Investor Protection Corporation, SIPC, under Section 3(a)(2)(a) of SEPA. What is the most accurate assessment of the firm's SIPC membership obligation? Option A. The firm is exempt from SIPC membership because it does not directly solicit customers and only uses an introducing broker model. Option B. The firm's size and profitability are the primary factors determining its SIPC membership obligation, and if it is not a large, profitable entity, it may not be required to join. Option C. SIPC membership is optional for firms that do not directly hold customer cash or securities, allowing the firm to choose whether or not to join. Option D. The firm is likely required to be a SIPC member because its registration as a broker-dealer and its role in introducing customer accounts to a clearing firm generally classify it as a broker under SEPA, regardless of whether it directly holds customer assets. The correct answer is D. The firm is likely required to be a SIPC member because its registration as a broker-dealer and its role in introducing customer accounts to a clearing firm generally classify it as a broker under SEPA, regardless of whether it directly holds customer assets. Explanation. This scenario presents a professional challenge because a registered representative must navigate the complex interplay between a firm's obligations under the Securities Investor Protection Act (SEPA) and the specific requirements for membership in the Securities Investor Protection Corporation (SIPC). Misinterpreting Section 3(a)(2)(a) of SEPA can lead to incorrect assumptions about a firm's coverage, potentially exposing customers to significant risk if the firm fails. Careful judgment is required to ensure compliance and protect investor assets. The correct approach involves a thorough understanding of the definition of a broker under SEPA and its implications for SIPC membership. A firm that is registered with the Securities and Exchange Commission (SEC) as a broker-dealer and engages in the business of effecting transactions in securities for the account of others, or holds customer securities or cash, is generally considered a broker under SEPA and is therefore required to be a SIPC member. This approach correctly identifies that the firm's registration status and business activities are the primary determinants of SIPC membership obligations, irrespective of whether it directly solicits business or operates solely through introducing brokers. An incorrect approach would be to assume that a firm is exempt from SIPC membership simply because it does not directly solicit customers or because it operates exclusively through introducing brokers. Section 3(a)(2)(a) of SEPA defines a broker broadly, encompassing firms that hold customer funds or securities, even if they do not directly interact with the end investor. Failing to recognize this broad definition and its implications for SIPC membership is a significant regulatory failure. Another incorrect approach is to believe that SIPC membership is optional for firms that meet the definition of a broker. SEPA mandates membership for all such firms, and failure to join is a violation of federal law. This approach demonstrates a misunderstanding of the compulsory nature of SIP membership for covered entities. A further incorrect approach is to focus solely on the firm's profitability or size as a determinant of SIP membership. SIP coverage is based on the firm's status as a broker-dealer and its handling of customer assets, not its financial performance. This approach ignores the core regulatory purpose of SIP, which is to protect customers of failed brokerage firms. Professionals should approach such situations by first identifying the firm's registration status with the SEC. Then, they must analyze the firm's business activities to determine if it engages in activities that classify it as a broker under SEPA, particularly concerning the holding of customer funds or securities. Consulting SIP membership rules and seeking guidance from compliance departments or legal counsel is crucial when there is any ambiguity. The ultimate goal is to ensure the firm meets all its regulatory obligations, including mandatory SIP membership, to safeguard customer assets. Question 18. Quality control measures reveal that a registered representative in California has submitted a written request to withdraw their registration with your firm. The representative is currently on administrative leave pending an internal review unrelated to their decision to withdraw. As the general securities principle, what is the most appropriate immediate action to take regarding the withdrawal request? Option A. Hold the withdrawal request until the internal administrative leave and review are concluded to ensure clarity on the representative's employment status. Option B. Process the withdrawal as a voluntary resignation and submit a termination filing without specifically initiating the withdrawal of registration process under Rule 15b6-1. Option C. Contact the representative to inquire about the specific reasons for their withdrawal and attempt to negotiate a different departure arrangement before proceeding with the withdrawal filing. Option D. Immediately initiate the withdrawal process by submitting the required documentation to FINRA, ensuring all necessary fields are accurately completed, and confirm the withdrawal is processed in accordance with Rule 15b6-1. The correct answer is D. Immediately initiate the withdrawal process by submitting the required documentation to FINRA, ensuring all necessary fields are accurately completed, and confirm the withdrawal is processed in accordance with Rule 15b6-1. Explanation. Scenario analysis. This scenario presents a professional challenge for a general securities principle in California because it involves navigating the complexities of a registered representative's withdrawal from registration while ensuring compliance with FINRA Rule 15b6-1 and California state regulations. The principle must balance the firm's operational needs with the representative's right to withdraw and the regulatory obligation to process such requests promptly and accurately. Failure to do so can result in regulatory sanctions, reputational damage, and potential harm to the representative. Correct approach analysis. The best professional practice involves immediately initiating the withdrawal process upon receiving the representative's written request, ensuring all required information is accurately submitted to FINRA via the appropriate system, e.g., FINRA CRD system, and confirming the withdrawal is processed within the regulatory timeframe. This approach aligns directly with the spirit and letter of FINRA Rule 15b6-1, which mandates prompt processing of withdrawal applications. Ethically, it demonstrates respect for the representative's decision and upholds the firm's commitment to regulatory compliance. Incorrect approaches analysis. Delaying the submission of the withdrawal request while the representative is on administrative leave, even with the intention of clarifying their status, violates FINRA Rule 15b6-1. The rule does not permit indefinite delays based on internal administrative processes or assumptions about the representative's future intentions. This failure to act promptly can prejudice the representative's ability to seek new employment or engage in other activities. Processing the withdrawal as a termination due to voluntary resignation, without explicitly following the withdrawal procedures outlined in Rule 15b6-1, is also problematic. The representative is voluntarily leaving. The specific process for withdrawal of registration is distinct from a standard termination for cause or voluntary resignation that might not involve a registration withdrawal. This could lead to inaccurate reporting on the representative's U4/U5 filings and create confusion for future employers and regulators. Attempting to require the representative to provide a specific reason for their withdrawal beyond their stated intent to withdraw, or to negotiate the terms of their departure before processing the withdrawal, exceeds the firm's authority under Rule 15b6-1. The rule focuses on the representative's affirmative request to withdraw and the firm's obligation to facilitate that process, not on the firm's approval or negotiation of the reasons for withdrawal. Professional reasoning. Professionals in this role must prioritize adherence to regulatory rules, particularly those concerning registration and withdrawal. When faced with a representative's request to withdraw, the immediate and primary professional duty is to initiate and facilitate the regulatory process as prescribed. Any internal considerations or administrative processes should not impede the timely and accurate submission of the withdrawal request. A proactive and compliant approach protects both the firm and the individual. Question 19. Regulatory review indicates that a registered broker-dealer in California has been sanctioned by the SEC under Section 15b(4) due to supervisory failures leading to unsuitable recommendations. The sanction includes a suspension for the firm's principal and a fine. Considering the impact assessment required, which of the following actions best addresses the firm's immediate and ongoing responsibilities? Option A. Pay the SEC fine promptly and await the completion of the principal's suspension period before considering any operational changes. Option B. Conduct a thorough root cause analysis of the supervisory failures, implement enhanced supervisory procedures and training, and proactively communicate remediation efforts to affected clients and regulators. Option C. Inform clients that the sanction is a minor administrative matter and that business will continue as usual with minimal disruption. Option D. Delay the implementation of any new supervisory protocols until the suspended principal returns to their role. The correct answer is B. Conduct a thorough root cause analysis of the supervisory failures, implement enhanced supervisory procedures and training, and proactively communicate remediation efforts to affected clients and regulators. Explanation. Regulatory review indicates that a registered broker-dealer in California has recently been subject to a Section 15b(4) sanction by the Securities and Exchange Commission, SEC, due to supervisory failures related to unsuitable recommendations. This sanction includes a period of suspension for the firm's principal and a fine. The firm's compliance department is now tasked with assessing the immediate and ongoing impact of this sanction on its operations and client relationships. This scenario is professionally challenging because the firm must navigate the direct consequences of the SEC's action, including operational disruptions and reputational damage, while simultaneously demonstrating to regulators and clients that robust corrective measures are in place. The principal's suspension creates a leadership vacuum, and the fine necessitates financial adjustments. Furthermore, rebuilding trust with clients who may have been affected by the unsuitable recommendations requires a proactive and transparent approach. Careful judgment is required to ensure all regulatory obligations are met and that the firm's ethical commitments are upheld. The best approach involves a comprehensive internal review and immediate, transparent communication with all stakeholders. This includes a thorough investigation into the root causes of the supervisory failures that led to the sanction, implementing enhanced supervisory procedures and training programs, and proactively informing affected clients about the steps being taken to prevent recurrence. This approach is correct because it directly addresses the regulatory findings, demonstrates a commitment to compliance and client protection, and aligns with the SEC's objective of deterring future misconduct and safeguarding investors. It also fulfills the ethical obligation to act with integrity and to rectify past wrongs. An approach that focuses solely on paying the fine and waiting for the principal's suspension to end without implementing significant procedural changes is professionally unacceptable. This fails to address the underlying supervisory deficiencies, increasing the risk of future violations and demonstrating a lack of commitment to compliance. It also neglects the ethical duty to protect investors and maintain market integrity. Another unacceptable approach would be to minimize the impact of the sanction to clients, perhaps by downplaying the severity of the SEC's findings or attributing the issue to a single isolated incident without acknowledging systemic weaknesses. This is ethically problematic as it lacks transparency and honesty, potentially misleading clients and eroding trust. It also fails to satisfy the regulatory expectation of accountability and remediation. Finally, an approach that involves delaying the implementation of new supervisory procedures until after the principal's suspension is lifted is also professionally unsound. This demonstrates a reactive rather than proactive stance towards compliance and risks further violations during the interim period. It prioritizes expediency over investor protection and regulatory adherence. Professionals should approach such situations by first understanding the full scope of the regulatory action and its implications. This involves a detailed review of the SEC's order and any accompanying findings. Next, they should conduct an honest internal assessment to identify the systemic issues that contributed to the violation. This assessment should inform the development of a remediation plan that includes concrete steps to enhance compliance and supervision, along with a clear timeline for implementation. Crucially, open and honest communication with clients and regulators is paramount throughout this process. Question: regulatory review indicates that a registered broker-dealer in California has been sanctioned by the SEC under Section 15(b)(4) due to supervisory failures leading to unsuitable recommendations. The sanction includes a suspension for the firm's principal and a fine. Considering the impact assessment required, which of the following actions best addresses the firm's immediate and ongoing responsibilities? Options: A. Conduct a thorough root cause analysis of the supervisory failures, implement enhanced supervisory procedures and training, and proactively communicate remediation efforts to affected clients and regulators. B. Pay the SEC fine promptly and await the completion of the principal's suspension period before considering any operational changes. C. Inform clients that the sanction is a minor administrative matter and that business will continue as usual with minimal disruption. D. Delay the implementation of any new supervisory protocols until the suspended principal returns to their role. Question 20. Consider a scenario in the state of California where a registered representative was initially registered on March 1, 2023, and is required to pass the Series 24 exam within 45 days of their registration date to maintain their qualification. The representative took the exam on April 10, 2023, and failed. As the principal supervisor, you need to determine the representative's current status and permissible activities. If the representative's initial registration date was March 1, 2023, and they have 45 days to pass the Series 24 exam, how many days do they have remaining from April 10, 2023, to pass the exam to remain qualified? Option A. The representative has 45 days remaining from April 10, 2023, to pass the Series 24 exam. Option B. The representative's qualification is immediately suspended upon failing the exam. Option C. The representative has 30 days remaining from April 10, 2023, to pass the Series 24 exam. Option D. The representative has 15 days remaining from April 10, 2023, to pass the Series 24 exam. The correct answer is C. The representative has 30 days remaining from April 10, 2023, to pass the Series 24 exam. Explanation: scenario analysis. This scenario is professionally challenging because it requires a principal to balance the immediate need for a registered representative to conduct business with the absolute requirement of ensuring compliance with FINRA Rule 15b7-1 regarding qualification. Overlooking or miscalculating the time required for a representative to obtain necessary qualifications can lead to significant regulatory violations, potential fines, and reputational damage for both the individual and the firm. The principal must exercise diligent oversight and possess a clear understanding of the regulatory timelines and requirements. Correct approach analysis. The correct approach involves accurately calculating the remaining time the representative has to successfully pass the Series 24 exam and obtain their registration. If the representative has 45 days remaining from their initial registration date to pass the exam, and they have already taken it once without success, the principal must ensure that the representative has the full 45 days to attempt the exam again and pass. This means the representative can continue to function in a supervised capacity for the remaining duration of that 45-day period, provided they are actively pursuing the qualification and are under direct supervision. This approach adheres to the spirit and letter of Rule 15b7-1 by allowing the representative the full statutory period to qualify while mitigating risk through supervision. Incorrect approaches analysis. Allowing the representative to continue soliciting business without a clear understanding of the remaining qualification period is a direct violation of Rule 15b7-1. This approach fails to recognize that the initial 45-day period is a hard deadline for qualification. Another incorrect approach is to immediately restrict the representative from any sales activity upon their first failed attempt. While supervision is crucial, Rule 15b7-1 provides a grace period for qualification, and prematurely halting all sales activity without considering the remaining time is overly restrictive and not in line with the regulation's intent. Finally, assuming the 45-day clock resets with each failed attempt is a fundamental misunderstanding of the rule. The 45-day period is a one-time allowance from the initial registration date to achieve qualification. Professional reasoning. Professionals should approach situations involving qualification requirements by first thoroughly understanding the specific rule, FINRA Rule 15b7-1 in this case, and its associated timelines. A critical step is to maintain accurate records of registration dates and exam attempts. When a representative fails an exam, the principal must immediately consult the rule to determine the exact remaining qualification period. This involves calculating the difference between the initial registration date and the end of the 45-day period. If the representative is still within this period, the principal should implement enhanced supervision and ensure the representative is actively studying and scheduled for their next attempt. If the period has expired, the representative must cease all registered activities until they pass the exam.